meeting of the Wooddale Community Development Commission. My name is Roy Sy. I'm chairman of the Wooddale Community Development Commission. Will the secretary please call the roll?
Dr. Madonna.
Here.
Mr. Milano.
Here.
Mr. Peterson.
Here.
Mr. Petrella.
Here.
Mr. Woods is not here, and I'm told that Georgia has resigned. Is that correct?
Yes.
Okay.
I'm here.
Oh, I'm sorry, Roy. Chairman Sy. Chairman Sy. Oh, yeah, you.
Okay, I declare our quorum present. We have one public hearing scheduled for tonight. All testimony will given under oath. At the hearing, there will be opportunity for the public to offer testimony and to comment. Following the public hearings in this case, our deliberations will be open to the public in the sense that all are invited to listen and to watch. The public, however, may not speak during our deliberations. The Unified Development Ordinance requires a prevailing vote by the majority of the members of the Community Development Commission for those matters that will be referred to the City Council for approval and those matters on which the Community Development Commission will make the final decision. We ask that the applicants here tonight provide a general description of their proposal and give a specific evidence to demonstrate that the applicant's proposal meets the standards of the Unified Development Ordinance for the relief requested. The burden is on the applicant to prove the case. With respect to others who wish to speak, you may give an opinion or present specific evidence as why you believe the applicant meets or fails to meet the standards for the relief requested. Finally, we will strictly adhere to the schedule prepared for tonight's meeting. In the case of an applicant or an event you or your attorney have filed an appearance as objector, you will be afforded sufficient time within which to present your evidence. Whether you're a member of the public wishing to make a statement for the record or witness testifying on behalf of the applicant or objector, you will be placed under oath and begin by stating your name and address. If you are not presenting evidence on behalf of the applicant or objector, your remarks will be taken after the applicant and all those who have filed an appearance as objector have presented all their evidence. You will be subject to question by the Community Development Commission and the applicant or objector. To allow as many people as possible to be heard, if you are not an applicant or objector, we would request that your remarks be limited to 5 minutes. If additional time is needed, the hearing will be continued until the next available hearing date. I will call the first matter before us this evening. Has everybody got all your cell phones off? The first matter tonight is case number 14 TA1 in regard to proposed tax amendment to amend the code providing pertaining recapture agreement. Will the secretary please call the roll?
Chairman Sy.
Here.
Dr. Madonna.
Here.
Mr. Milano.
Here.
Mr. Peterson.
Here.
Mr. Petrella.
Here.
I declare a quorum present. Jennifer, please indicate when notice of hearing was published and whether as secretary you have the certificate of publication from the newspaper.
Yes, I have the certificate. It was published in the Daily Herald on January 5th.
Who's going to do the presentation tonight?
I will.
Okay, you'll have to be sworn in.
Would you raise your right hand, state your name?
Jennifer Hennigan?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. All right, thank you very much. Last month at the Planning, Zoning, and Building Committee, the council directed staff to proceed with some amendments to the UDO pertaining to recapture agreements, specifically that the interest guarantee be removed, and these agreements would be considered on a case-by-case basis from now on. Staff did prepare a memo, which is submitted to the record in its entirety with some background information on what recapture agreements generally are, In summary, developers may request a recapture agreement when they install a public utility across the frontage of parcels who are not currently receiving a service from the city. Then, when the owner of that parcel requests service, a prorated amount for the installation costs may be collected by the city and returned to the developer. Some previous recapture agreements that the city has entered into have, over time, resulted in some payments that could be a significant financial burden for property owners, with the interest payments in particular being an issue. When recapture amounts become burdensome, they can impede the development of affected properties. A property owner may choose to forego annexation or connecting to city utilities or if he or she cannot afford to pay the recapture amount on top of the normal costs of development. Also, if the recapture amounts are so substantial that they discourage any additional development, the original developer who installed the improvements is unable to recoup any of the costs since he does not get reimbursed if no one pays. In that situation, a developer could end up paying the full cost of installing the public improvements and never receive any financial reimbursement of any kind. Since 2010, the UDO has guaranteed developers a 6% interest rate. Although it is capped at 33% of the original principal amount, this still can be a significant deterrent to the improvement of surrounding properties. And so staff is recommending that since Illinois state statute allows municipalities to enter into recapture agreements, there's no need to duplicate that within the city code. Staff is recommending that the council consider recapture agreements on a case-by-case basis and should be able to modify the terms of the agreements as may be appropriate. The city would have the option of entering into recapture agreements where appropriate, but they would be governed by a city council policy rather than a mandate within the UDO. And that concludes staff's recommendation.
Is there any questions for Ms. Hennigan? Rich?
Well, I think there shouldn't be any restrictions. They should follow the state recommendations, the state statute. I don't believe they should be tampering with interest. I think that anybody that enters into one of these agreements has expenditures where perhaps they borrowed money or they laid out money, and the cost of money at that time was perhaps 9% or 7% or 10%, 15%. By doing so, they should be able to recapture that cost. It should be shared by anybody that is part of the recapture agreement. But just because they can take advantage of this situation and not have a shared cost. I think it's unfair to the person that does the improvements, and that's my thoughts on that.
Donna?
Yeah, just a couple questions. Number one is you were talking about removing the interest. As I'm reading the ordinance, there are two applied interests. One, it would be reimbursing the developer for his costs at whatever the percentage is. And the second one is there's a 6% charge by the city itself. Is that correct?
Yes, that is a one-time fee that is added on at the end when someone pays that recapture amount. There's an administrative charge to the city.
Okay. The only thing I see that, and I'm not sure what prompted it, the only thing I see, having been both the recipient of a recapture and also been involved in a recapture, the only thing I see is, as Rich was pointing out, is that to me, is if the cost of an improvement today may be $100 a linear foot. It's not, it's much higher than that. But 5 years from now, that cost is not going to be $100 a linear foot. It's probably going to be $150. So if I'm coming in 5 years later and I'm basically paying that person $100 a linear foot, which is what it cost to begin with, and you've eliminated any interest on that money, I'm the one who is benefiting. And yet the person who put it in may have to wait 5 years, may have to wait 10 years, who knows how long. And obviously the cost of everything has gone up. Certainly the cost of the water improvement, the sewer improvements have gone up. The interest on the money, we're dealing with money that was the value of the dollar today versus the value of the dollar 5 years from now. So it seems to me that what we're doing is we're benefiting the person who doesn't want to go in initially, waiting for a number of years, and then he's going to go ahead and be the beneficiary of a price of 10 years ago. Be like someone coming into me and saying, we're going to build your house, and in 10 years you can buy it at the same price it cost me 10 years previous. And that's my biggest concern. And again, I don't know what prompted it. I don't know if the city is close to a recapture, but those are my thoughts right now.
Hennigan?
I just wanted to underscore something that was in the memo here. We had spoken with the staff from some of the municipalities that don't allow interest payments for recapture, Addison and Lombard specifically, and their reasoning for doing so is that by not allowing interest, that takes into account the depreciation of the lines themselves. So if someone hooks up 10 years down the road, they're hooking up to a 10-year-old main that will need replacing rather than something that was brand new and just installed. So that's part of the rationale of why some other municipalities do that.
But usually that person would not be responsible for the depreciation. The city is going to have to assume that responsibility. If there's a water line in front of my house and I hook up 10 years from now and it needs repairs, it's not going to be done by me personally. I'm going to be responsible for that portion across the frontage of my lot, but eventually if there's a breakdown, it's going to be the city that's going to be involved. So I'm not so sure if that argument holds, so. But thank you for your response.
Any other questions? Rich?
Yes. My recommendations as a person who has experienced the misgivings and poor judgment shown by the city, actions in my case are, we should have one standard for all recapture agreements, the state statute. All city codes should be enforced evenly. All standing agreements should be enforced. When a party funds a project and the funds said project with their own money, not only to better themselves, but to save the city from financing their projects. It is only fair to recapture these costs at the current rate that money is being lent. If so-called excessive interest payments or windfall profits have a potential problem, then a specific timelines such as 1 to 5 years should be part of any agreement so that there is a conclusion to these agreements, excuse me. This way, it would minimize the dollar amount of recapture agreement payments and also require compliance with city codes, making it fair to everyone involved. When it comes to not wishing to enter into recapture agreements by the city, that means that the improvements would have to be funded by the city at their expense, not by the developer. Thank you.
Do you have any thought on this?
I think not on the issue that you're debating here, whether or not it is appropriate to charge interest or not, or whether under Illinois statutes you wish to simply remove any recapture provisions from the UDO, any mandated recapture from the UDO, or not. That is discretionary with this board here, and to, based upon the recommendation that you would be made. I do see here two sort of issues. One is simply amend the UDO to eliminate the interest provisions, and then the other recommendation that I'm hearing here also is that all recapture be eliminated from the UDO so that it's a policy that is in discretionary with the city council. So I think there are those two separate issues here, which this board, you know, is capable of addressing.
Okay, we have the two separate issues. Now, would we have to vote as two separate issues, or can you combine it? What would be the best?
Well, I think the board is going to make one recommendation. Let me say this, that if you are going to not go along with the recommendation that there be no interest, if you are going to, if it's the desire of this board to recommend interest, that there be interest on this, and also a city administrative fee, that 6% fee, you are going to have a provision in the UDO for that. Now, you could, the options that you would have would be no interest, a city administrative fee of 6%, or the interest rate, well, the interest rate is shown as varied here, but that would be that would be the option. City fee, no interest rate, maintain the recapture, or if you are going to eliminate the requirement that there be recapture and allow it, as Jennifer had said, on a case-by-case basis, then you're going to take this whole recapture provision out of the UDO.
Okay, whatever decision we make tonight will not affect any recapture agreements that are out there, right?
No. The existing recapture agreements, this would be prospective only. Constitution prevents any kind of action by a governmental body that affects contracts already in effect.
So basically, we could adopt the Illinois state statute regarding municipalities to enter recapture agreements and modify it that the city gets 6% administrative fees?
Well,
Is that right? If I got that right?
if that is the case, then what you are going to ultimately do is probably retain the recapture provisions in the UDO. If you're going to make a motion to eliminate interest, but retain the 6% administrative fee, then you are going to require recapture agreements for each development.
On a case-by-case basis, right?
Well, I think the recommendation I'm hearing from Jennifer is that the UDO be amended to eliminate recapture. Is that correct?
Correct, eliminating the guarantee, so that we may have mentioned that recapture agreements are possible, but will be considered by the council on a case-by-case basis.
Okay. So you can provide that in there, but it's pursuant to Illinois, there would be a reference to Illinois, the authority under the Illinois compiled statutes to enact recapture agreements, but it would be on a case-by-case basis. So in effect, what you would be doing then would be amending the UDO to eliminate basically all of these provisions here in section 17-702 and just reference the city's authority under the Illinois revised statutes to enact recapture agreements on a case-by-case basis. I think the initial issue you want to deal with is whether or not you want to eliminate the interest payment, because if you wish to retain the interest payment on a recapture agreement, you're going to have to provide for that in the UDO.
Well, So then the best thing to do is just go with the Illinois state statute then.
Well, if you want to retain, you've got one issue, whether or not you want to make it discretionary with the city council. The second issue is whether or not you want to retain an interest rate on it. Then you've got to provide for an interest rate on here.
What the interest rate would only be for the administrative costs of the city.
Well, there's two, as I think Dr. Madonna pointed out, there are two. There's a
Right.
6% for the city, that's a flat administrative fee. Then there is an interest rate, which appears to be variable here, based on a capture agreement. But you would have to make a provision then for interest.
Roy, if I may? The other thing that if you look at the statute itself, or you look at our UDO itself, Section C, Section C provides, and I hope when we're discussing a recapture, that we keep in mind, that Section C actually allows, if I were a developer, I can pay to the city to have the city put the improvements in, but I'm going to pay the cost of those improvements, rather than me be responsible for the improvements. And in looking and in reading the whole ordinance, I'm a little bit confused as what the intent of the city council is. I think Jennifer did as good a job as she could to try to explain it, but I'm still having a little bit of hard time saying, I put the improvement in, why shouldn't I not get some reimbursement besides just the initial cost, since my money has been out all this time? I put the improvement in today, and I'm gonna wait for a period of time. There should be at least some differential between the cost that I put in today and what I'm going, some reimbursement. You know, there should, to me, it's a person doing that, putting it in front of someone else's home and waiting for that person to make that decision. It's just a benefit to that other person. And yet, he's out the money for a long period of time.
You know
Go
what,
ahead.
actually, in the public hearing now, is there anybody that wants to testify?
Okay, go ahead.
Okay, we have two aldermen here. Maybe you could bring us up to speed on what the council has, what their thoughts are.
Is it anybody,
Well, you'll have to be sworn in. You'll have to be. First, am I allowed to talk? Pardon? Oh, you don't think you're allowed to?
it would be probably my recommendation, no, that you not be, but so we don't have any
Okay.
interest. We have to.
Okay. Okay.
Excuse me.
Okay,
So in other words, we're coming here with just half the story. We don't know which way the council is going, and so we're it's kind of a crapshoot here tonight. Whatever we do here, it might not be what the council is looking for, so we're gonna have to do the best that we can, and maybe in 3 months, you're gonna be back with the same issue again, too. Until you guys, you know, put a pencil to it and say, oh, no, we don't, that's not what we're looking for here, so.
We're in the public hearing, there's nobody here, do you want to adjourn the public hearing then? Because we'll go back and discuss
Okay.
this.
Is there any other discussion?
Or anybody else have?
I'd just like to make a statement. I think by amending the state statute would be stifling development. And I also think the city charges of 6% are also a windfall for a few hours administration work, with paperwork. I think it's outrageous. There ought to be a flat fee. Thank you.
Dr. Dunn?
Yeah, is it possible then to, because apparently we're talking about the 6% that is spelled out specifically in the UDO, is it possible to somehow make a motion that that fee be decided by the city council on a based on the prevailing scale at that time? I mean, today, 6% may be pretty high, but there's some here for 9%, there's one here for 10%.
You're talking about not this, you're not talking about the
No,
administrative.
I'm talking about the developer portion.
The developer portion,
Yeah, because the 6% administrative
there is, right, you can make some kind of a recommendation on that. Although, we're in the public hearing right now, so
Right.
we're kind of going to be discussing this afterward. I don't know whether there's any more basically, this was it started out that you were to ask the staff questions there because the
Right.
staff were presenters. There's nobody that is here to testify, so maybe if there is no other information to be gathered about this, maybe we want to close the public hearing on this and
And go,
move on to
okay.
the next public
Okay.
hearing.
Is there any other questions for Ms. Hennigan from the commission? Hearing none, I will entertain a motion to close this public hearing. Later during this meeting, the commission will commence deliberations on the petitioner's request. Do I have a motion?
I'll move to close the public hearing.
Have a second?
I'll second.
There's been a motion and second. Will the secretary please call the roll?
Chairman Sy,
Yes.
Dr. Madonna,
Yes,
Mr. Milano,
Yes.
Mr. Peterson,
Yes.
Mr. Petrella.
Yes.
Okay. Good. Are they going to hearing on that tonight? Right, hearing on this tonight, okay.
Okay, the next case we have is case 14 TA2, medical marijuana land use regulations. The city of Wooddale is requesting a text amendment to chapter 17 of the municipal code of the city of Wooddale. The purpose of this text amendment is to create land use and zoning regulations for medical marijuana dispensaries and cultivation centers as defined by the Compassionate Use of Medical Cannabis Pilot Program Act, Public Act number 98-0122. Jennifer, are you handling this?
Yes.
Would you raise your right hand, state your name?
Jennifer Hennigan?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Thank you. As I'm sure most of you know, since January 1st, the state of Illinois has allowed the legalized use of medical marijuana. As part of their legislation, there are restrictions concerning two types of land uses related to medical marijuana: cultivation centers and dispensaries. Local governments cannot completely prohibit these facilities, but they can enact reasonable zoning regulations in addition to the standards that are prescribed by the state for minimum separation distances. No one has yet proposed to locate any type of medical marijuana facility within Wooddale. However, per the recommendation of the city attorney, the CDC is being asked to consider some amendments to the UDO to determine where these types of facilities may be appropriate in the event a petition is ever brought forward. Staff did prepare a very lengthy memo, which is submitted to the record in its entirety. We had looked at the state regulations, which requires a minimum 2,500 separation distance between any cultivation center where marijuana is grown, between that and any school, daycare, or residentially zoned area. Applying those regulations to the city of Wooddale, there are no areas within the city that are eligible for a cultivation center per the state statute. Dispensaries, however, only have a 1,000-foot separation distance, and there's no separation required from residentially zoned areas. So there is a map in your packet showing a few areas where it would be allowable. The DuPage Mayors and Managers Conference prepared a report on medical marijuana, seeing what issues communities are looking at in terms of land use, police enforcement, and its impact on human resources departments. Many communities are adopting a wait-and-see approach, choosing not to do anything to their ordinance until anyone comes forward with a petition to locate a dispensary or cultivation center. However, there are a few communities that have amended their zoning ordinance or are in the process of doing so. Addison allows them as permitted uses in their M2 industrial district. And in Itasca, they're a special use in their industrial district. Staff is recommending a similar approach as Itasca, limiting marijuana dispensaries to special uses in the I2 district. That district is established for locations that may have a deleterious effect upon the adjacent area. For this reason, there are a number of types of land uses that are restricted only in the I2 district, such as pawn shops, tattoo parlors, psychic card readers, and a few others. By limiting it to a special use in the I2 district, there are only 23 properties where it would meet the state separation requirements, half of which are municipally owned, and that would leave 12 privately owned properties where this could be a potential special use in the future. So staff is recommending that the CDC require or amend the ordinance to allow medical marijuana dispensaries as a special use in the I2 district. Also, the CDC could choose to amend the ordinance to include cultivation centers, knowing that there's nothing in the ordinance, or knowing that there are no properties within the city that currently meet the state statute requirements. Those separation distances may change as the state's currently looking at that ordinance, finding out how it applies. This would take care of it, the possibility that the state separation requirements would be changing, and so we would have that addressed just in case.
So basically, tonight, all we're doing is establishing an area where a possible medical marijuana dispensary could be located. And then we could do that under the special use, correct?
Correct.
Any questions for Ms. Hannigan?
Very briefly, you did, the cultivation center, you did suggest that we do the same thing, that cultivation centers be restricted as a special use in I2 district, in case in the future the law changes. Right now, apparently it could not be a cultivation center in Wooddale at all.
Right. Staff's recommendation would be to include the cultivation centers, just so it's addressed in the UDO.
Any other questions? Mr. Peterson? Any questions? Well, hearing none, I'd make a motion to close this,
I'll second your motion. Close the public hearing.
close the public hearing. Roll call, Marilyn?
Alderman, excuse me, Mr. Sy, Dr. Madonna,
Here.
Mr. Milano, Mr. Peterson,
Here.
Mr.
Yes.
Petrella.
No, it's yes.
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 We're all yeses.
Oh, I tell you, it's a big day today.
Yes.
Okay, the next item is approval of meeting minutes from December 16, 2013. Need a motion?
I'll present that motion.
Do we have a
I'll second it.
Do we have a second? Okay. All in favor?
Aye.
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 One abstention. I was not at the
Okay.
meeting.
One abstention, Marilyn.
Okay.
Okay, the next item we have is the report and recommendation in case number 14-TA1 recapture agreement. The city of Wooddale is requesting a text amendment to chapter 17 of the municipal code of the city of Wooddale. The purpose of this proposed text amendment is to amend the code provision pertaining to subdividers and developers' right to reimbursement for improvement of certain thoroughfares, utilities, and
Appurtenances. Appurtenances.
I've never seen that word before, so.
Appurtenance.
Okay. Okay, we kind of discussed this, and I don't know which way we want to go on this.
Yeah, I'm not sure either.
Maybe you invite someone to make a motion specifically what they want to do. It might be useful to have Jennifer restate the specific recommendation that the city is making on this, okay?
Jennifer, you want to repeat the recommendation for the city?
Sure. Staff's recommendation was to remove the guarantee of interest payments from the UDO and allow the city council to consider recapture agreements on a case-by-case basis.
Then you might ask if anybody has a motion. You might ask if anybody has a motion to make with respect to the recommendation.
Does anybody have a motion to, for Jennifer's recommendation?
I'd make a motion to reject it and leave it as is.
Okay, we have,
Okay, one moment, please.
okay.
Jennifer, your recommendation, first of all, would you repeat it, please?
Staff's recommendation is to remove the guaranteed interest payments from the UDO
Okay.
and allow the city council to consider recapture agreements on a case-by-case basis.
Okay, I'll make that as a motion.
Well, and I
Oh,
think Mr. Peterson
oh,
already
okay,
made
Mr.
it.
Peterson.
So, Mr., there's a motion on the floor then
Okay.
to reject the recommendation, which would mean to reject both the recommendation for elimination of the interest rate and also for, on a case-by-case basis. So it would be rejecting both aspects of that.
He has to have a second.
He has to have a second.
Do we have a second to Mr. Peterson's?
Mr. Peterson, you are rejecting the motion as described by Jennifer?
Yes.
Okay.
I'll second the motion for the purpose of having a discussion on it, and I just,
Okay.
if I
discussion.
might, but I will second it so it stays on the floor.
Okay.
And then if I can, if we look at the UDO currently as it is, I think the easiest way to look at it would be to go to section D. I think we all have a copy of it too. It says a right to reimbursement from a later adjacent developer or subdivider, which is apparently what Jennifer is trying to eliminate. Because you're suggesting, apparently, you're suggesting that that is a mandated right that they have. Jennifer, I'm looking at 17702D. Is that the basis that you're using for saying it's mandated?
Yes, the language that developers shall be entitled to reimbursement.
Okay. Okay, what if in fact that we just we amend this portion of it and say, eliminate the shall and make it a may? And then that would then allow the city council to negotiate whatever it would like to do with it. And at that point in time, I think I would then change, and again, it's just discussion, I'm not making a motion, but then change the 6% per annum to be the prevailing rate. And that would allow some negotiations between the developer and the city. Because I think that's the only portion that I see that we're really discussing this evening.
Keith, what's your thought on that?
Well, we've got a motion now. Mr. Peterson has made a motion. I don't know whether Dr. Madonna is making an
Oh.
amendment to that motion or,
At this point, no, I'm just, what I'm doing is I'd like to get some, opening it up for discussion.
okay.
We're still under his motion right now, but I'm opening it up for discussion. In fact, I would ask
Okay, you're not making an
Not
amendment?
yet.
Not, okay.
I'm just, I'm seeing if we can get to where we want to be as quickly as possible with just a few words as possible. And I think the whole hang-up is that apparently the city does not like the idea that there's a mandated, if the developer puts in a utility line, that's mandated that there is a recapture. And I can see some possibility where that may not be the wisest choice for the city. But that developer should be able to negotiate with the city to say, why not? And that's what I'm looking to do. Apparently, the city is looking to do it on a case-by-case basis, but I don't want to see the rest of this ordinance changed just because we want to make it a case-by-case basis. That's my point.
Any other comments?
Okay, does somebody want to call the question on Mr. Peterson's motion then? It's
Anybody
been
wanna
moved
call
and
it?
second. It's been moved and seconded, Mr. Peterson's motion,
Okay,
which was to reject both recommendations by the staff.
okay, we have a motion on the floor and second. Roll call, Marilyn?
Mr. Sy? Motion to reject.
To reject? No.
Dr. Madonna?
Yes.
Mr. Milano?
No.
Mr. Peterson?
Yes.
And Mr. Petrella?
No.
Okay, so you've got three noes and two ayes, so the motion fails.
3 noes, 2 yes, motion fails.
The motion fails. Dr. Madonna, would you like to?
Yeah, I'd like to make a motion that we send to City Council Section 17702D and change the word shall to may, wherever applicable in that whole paragraph, and change the percentage under item 1, amount of reimbursement, change the rate from 6% to a prevailing rate. So in other words, a developer would be entitled to some rate, and I think it would then be able to be negotiated by the city council.
And are you gonna leave that compounded annually in there?
Well, I don't see it compounded annually. I would take out the compounded annually, but I would also suggest that the maximum be the 33%.
The maximum be what?
The 33% that's in the
Oh.
ordinance currently.
Okay.
All right, just to clarify then, you wish to give the city council the discretion on the case-by-case basis.
Correct.
If they decide that they do want to do a capture agreement, then are you mandating, does your motion mandate then that they provide for interest to the
Yes.
developer? Okay, all right, just so that's clear.
Yes. They have the ability to negotiate a recapture, but if they have a recapture, there is going to be an interest to the developer. It just won't be a specified 6%. It may be 3%, it may be 10%, depending upon the prevailing rate. All I'm saying is that I believe the developer who puts in a line is entitled to some reimbursement above and beyond his own costs. That's the point that I'm making. However, I do see where the city may want to have some flexibility in that every developer putting in a line is not required, is not entitled to a recapture. That's the motion.
That's your motion.
That's the motion.
Is there a second on it? Or a question, or a second?
Yeah. Dr. Madonna, can you just, one
Wait a
more
minute,
time?
sir. Are you gonna second?
No, I have a question.
Yeah, well, you have to second, then you can have the question.
Second, they can,
All right, I'll second that.
yeah, this
Okay,
way we
and a
can talk
question.
about it.
You made a few key points that I definitely agree with. Can you just one more time spell out exactly what you're recommending?
What I'm recommending is that, again, we're recommending to the city council that they look at this UDO, this one portion of it, and where it is mandated, because the word shall is in there, that they change the shall to may. So in other words, the developer may be entitled to recapture. That's going to give the city council the flexibility it needs to negotiate. However, I'm also saying, contrary to what the recommendation of staff is that if a developer does that, he should be entitled to more than just his initial cost. There should be some interest check. There should be some interest on the money. He may have to wait 10 years for reimbursement. So those are the 2 points. One, I agree with the staff, one, I don't agree with the staff.
Dr. Madonna, if I can just make a suggestion to your
Sure.
language so that it's clear here, because I think this gets the sense of what you want in it. On D, right to reimbursement from later adjacent developer or subdivider, the city council is authorized to determine whether a subdivider or developer shall be entitled to. So that then clarifies that the discretion then is with the city council.
Oh, okay.
Shall I read that again?
Yeah, tell me at what portion of it.
Okay,
Put it in this paragraph as you would have it worded.
okay. Right here, I'll read it as I have reworded it here. Right to reimbursement
Right.
from later adjacent developer or subdivider. That's the heading, we're on D.
Okay,
Then, following that, the city council is authorized to determine whether a subdivider or developer shall be entitled to improve a thoroughfare or utility pursuant, shall be entitled to reimbursement for a portion of his expenses. I'm sorry, let me read that again. The city council is authorized to determine whether a subdivider or developer required to improve a thoroughfare or utility pursuant to section 17702B hereof shall be entitled to a reimbursement.
Attorney Leshy, I need you to say part of that again.
Okay,
Okay.
all right.
The city council is authorized to determine
Determine whether a subdivider or developer required to improve a thoroughfare or utility pursuant to section 17.702.B hereof shall be entitled to reimbursement for a portion of his expenses, etc.
Doesn't the word shall?
Well,
It's
it
just
gives
it's a generic-
discretion,
Okay.
shall be entitled or not be entitled. Okay, that's the understanding there.
Okay, so that okay.
Yeah, so that is discretionary.
my only concern is this, is that I cannot think of a reason why the city council would say to a developer, put in this line, but you're not gonna get reimbursed. And that's the only reason I'm nervous about it is the fact that, is this gonna be a determination made politically as opposed to what should be the right way? That's my only concern about the whole changing of this whole ordinance, really, is that I hate to see where it becomes like, wow, do I have enough city council people on my side to get a recapture? If a line is put in and someone else is gonna benefit from that line, why in the world would they not be entitled to at least recapture something on a per foot basis? I just can't fathom why the city would say, let's do it on a case-by-case basis, and where would we not put in a line? But
John, you want to comment?
Yeah, I'd just like to make one quick comment. As Jennifer started out her presentation, staff was basically directed by the PZB committee to look into this and bring this forward to this committee. I don't believe anybody on the city council would not want a developer to recoup his costs for putting in a line that may serve a property, you know, not immediately. I mean, it could be vacant, unimproved property that could sit there for 10 years before somebody develops it, or it could be a fully improved street where utilities currently do not exist. But what we found the last couple of years is that some of the older recapture agreements, the interest rate has gotten that recapture amount to such a point where people are choosing not to build on these vacant lots. I mean, we have a situation right now where the recapture agreement is actually more than the value of the vacant lot. So it's causing people not to develop on the lots, and in turn, the developer who put those utilities in is not recouping his costs either, because there's no development happening, because the costs are just out of whammy. So,
Are they at whammy even with the 33% that cap that's in the ordinance now?
well, again, if you extrapolate that out for 10, 15 years, that can be
As I
quite a bit
understood
of
it,
money.
this is 33% of the original principal cost, period. If I put in $100,000, the most I can get back is $133,000.
Is that-
Yes, that's current for new recapture agreements. The city hasn't done any recapture agreements,
Under
though,
this,
since that was
okay.
passed.
Okay. So we have not done any under this 17.702 as of now, okay.
Correct.
With that provision was not in the old zoning ordinance, I don't believe. The provision maxed out at 33%. Well, have we resolved the problem with this new ordinance? In other words, all I'm looking at is I put out $100,000 and am I entitled to $133,000 10 years later? And that's and if I am, maybe the ordinance as a whole should just stand. So, I don't want to belabor the point, I mean, obviously, but
Mr. Peterson?
I have a question. What if it's 20 or 25 years later? Are you still entitled to $133,000?
that's it. 33% is the max in this
Well, isn't that
ordinance.
ridiculous?
Well, in some ways, yes, but I mean, they're, you know.
Well, I think by not enforcing the codes and putting a time limit on these recapture agreements where they are enforced, or the city take over payments afterwards, after a 5-year period or a 4-year period or whatever they want to make it. So the initial developer can recapture his agreement that he made with the city. We're looking at a couple of these now. Mine is, I'm involved in one, it's 25 years. And the city council gave people an exemption that they didn't have to hook up. And so they don't have to comply. So there ought to be culpability with the interest payments going up. If the city won't enforce their codes and they give an exemption to people, how is the person ever supposed to recapture their initial costs? 25 years is ridiculous. Some of the phrasing in these agreements are a reasonable amount of time. There is no statute for a reasonable amount of time. If you look in it's up to the discretion of the city's lawyer or anybody else on the city council. What's a reasonable amount of time? There's too much wiggle room. It's too political. Like you said, it's up to a handful of people on the city council as to whether they want to, and most of them aren't informed of what's really going on here. And I think if you limit the amount of interest, I could go along with that, but it should be a reasonable amount or a floating amount. It could be varied from year to year as interest rates go. If the cost of money is at 9% one year, and it's at 6% the next year, and it's at 4% the next year, and it's at 2% the next year, you could average it out or adjust it accordingly in a contract. And then it wouldn't be an absorbent windfall. I'm just trying to be fair to all parties.
Well, I think that would be up to the council to
Well,
when they.
What I'm trying to say is there's too much wiggle room, there's too much fog in the whole system. I mean, it can be interpreted by 10 people 10 different ways.
Right.
If it's a shall, and a must, and the language in a contract, where there is no wiggle room, there wouldn't be this fog. There wouldn't be a problem with collecting these recapture agreements or any other. If the city council's got so much
Leeway?
wiggle room, one guy's gonna wiggle this way, the other guy's gonna wiggle that way. If it's written out in plain English, and the state statute says one thing, I don't understand why we can't follow the state statute. It makes it clear to everybody when they enter into an agreement. It's not a hocus pocus, how are we gonna do this?
I agree with Rich, I don't like giving anybody that amount of power or the discretion to go by a case-by-case basis. I don't like the thought of that, I really don't. Is there any way possible that we can maintain the recapture agreement, okay? And, I'm in full agreement, a developer should recoup his money. However, he should recoup his money. I don't think he should be paid anything over that. Okay, especially if it's 10 or 20 years down the line. Why can't we maintain the recapture agreement? Maybe move the city fee around if we don't like the 6%, maybe adjust that and eliminate the interest.
Well, maybe we could adjust it, like I said, annually. So it's current.
I don't think, why should he get interest?
Why should he get interest?
I'm still, yeah, I mean, if it were me, and I put 10 feet of pipe, and it was $100 worth of pipe, I would expect to get that back, okay?
Right.
But why would I have to get interest on my 20-year-old pipe? Why should the buyer, the homeowner, or whoever's going into that, have to pay on something that was put into the ground 100 years ago, and,
Well, in my case,
maybe I'm misunderstanding it.
I paid for the improvement up front,
Okay,
and all these other people share, or will share, in my
right,
improvement.
okay,
But I had to pay for that money.
okay.
I had to pay, for the last 25 years, I had to pay interest on that money
So.
to the bank, so I
how
could
do
do
we-
these improvements.
Correct. So how do we establish, how is there an interest rate that would be fair?
Well, I'm just saying,
to be-
can't we do it on an annual basis? If it fluctuates from 9% to 7% to 4%,
And the
it'd be the current annual rate of money at prime interest rate.
Okay.
Wouldn't that be?
And the compound, what do we do with that? That
Well-
compound interest?
In the state statute, it says that you're allowed to compound it.
Yeah,
Now, I made an agreement with the city, with mine, that it would be straight interest, because they considered it absorbent, and I went along with it because the interest rate fell. I said, well, just pay me straight interest, instead of compounding it. By compounding it, you double your money every 7 years.
Right.
By straight interest, you're collecting straight interest.
right, okay. Agreed.
So I negotiated fairly with the city, and I still can't collect my money. Because they refuse to make these people comply with the ordinances. And every time we have a meeting with them, you gotta have it in secrecy. And the city council doesn't know anything about it. I hear them come out here and say it's a windfall, and it's, gratuitous and everything else. It's not their money. I'm just trying to be fair to everybody. Everybody, if they would have hooked up in the same amount of time in a couple of years, it wouldn't have been a lot of money. 25 years down the road, it's a lot of money. I agree. But the city's got to have culpability here. If they grant, and that's political, if they grant somebody an exemption for not hooking up because he doesn't want to hook up, I or any developer will never collect their money. They completely destroy your contract. And I've even brought it up to the city a couple times. If they think it's gratuitous, this amount of money, then they should take over the thing and let them get the gratuitous amount of money and pay me now. They can hold on to it for 25 years and the water and the sewer will be twice that. And they can make the money. I could be long gone before I could collect any money. And all I did was in good faith.
Dr. Madonna, you have a comment?
Yeah, just, are these, as I'm looking at the staff report, are these the only three recapture we currently have on the books?
Yes.
The three that you showed? Okay, one is 29 years old, one is 14 years old 10 years old according to this, and the other one is 6 years old. So, the more I look at it, the more I hear the discussion, would the seconder withdraw his second on my motion, because I want to withdraw the motion? And I think we can arrive at a better conclusion.
So we're
Tony,
going to
you made the
withdraw
second.
your motion and make another one?
Yeah, I think so. I
Okay.
think we can do this a little bit easier.
Has the second withdrawn the
He
second?
has to withdraw the second.
We would
Tony, would you please?
I withdraw.
And I'm going to withdraw the motion as a whole. So we have nothing on the table currently. After all the discussion that I'm hearing, and I think two issues that should be separated. A developer who puts in a line across someone else's property should be entitled to some return. And I say should be, shall be, and I think that should stay in there. However, where I have a little bit of trouble is the 6%, I think should be a prevailing, whatever the prevailing interest rate is, and I would recommend the city council eliminate the compounded annually. And I think the fact that you have a cap of 33% protects everybody. It does. I mean, that original developer is running a line across your property and getting nothing for that line across your property, and I think there has to be a reimbursement. So my new motion would be section 17702, the only change being in item 1, the amount of reimbursement shall be at a prevailing rate, and I would eliminate the compounded annually. And I would keep in not to exceed 33% of the original amount.
Did you wish to say, Dr. Madonna, prevailing prime rate of interest, is that?
It would be prime rate of interest, yes. We can add the term prevailing prime rate of interest, but eliminating the compound annually.
So then we've got that motion. Is there a second?
Do you have that, Marilyn?
Do you have, yeah,
You're asking city council to
Correct.
review section 17702B.
D, David.
D, all right.
D1,
D1. D1, so that it shall be at the prevailing prime rate, and you want to eliminate the wording compounded annually, and you want to keep in not to exceed the 33%.
correct.
Okay, we have a motion on the
So
floor.
that is your motion, and we need a second.
A second. I'll second it.
Okay, I'd like to,
What, you have questions on the
a
motion?
question. I'd also go along with everything Dr. Madonna said, but I would like to add in a time restriction on these recapture agreements so they don't go on indefinitely, and it would hasten the payment of these recapture agreements.
When you say if you're going to terminate the agreement, then, just for clarification, when you say you're going to impose a time limit on, so the agreement terminates then?
It doesn't terminate, it's enforced. It's brought to a conclusion.
Well, enforced, you mean enforced against a developer?
No, it's enforced against anybody that is part of the recapture agreement. In other words, if there's a person on, in the recapture agreement, and he has the, benefit of the recapture agreement, that he's made to make it whole.
You're talking about an existing home that's staying right next door.
Right.
John,
That he'd be,
John will comment on this. or-
well, I think he ought to be, forced to abide by the city code. And we have city code that it shouldn't be up to the, political arm of the, city council to decide whether he should or shouldn't. Whether he gets an exemption or he doesn't get an exemption. Because it nullifies the agreement.
Rich, I think everybody knows where you're going there. Let John comment on this, and then.
Well, that's all right. It's fine.
Yeah, the only thing I would say about that is that may work in an area that is fully developed and there are properties that are not currently taking advantage of the utilities, but how would that impact, say, a 4-acre vacant piece of property, and you run your lines, you know, in front of that vacant piece of property, but that property's not developed for 20 years? I mean, what kind of a sunset would you put on something like that?
Okay, well, the sunset would be that he doesn't have to run it down the entire, project. He only has to take it to his, one past his house. And his agreement is over. Why does he have to do the whole neighborhood?
I'm just saying, if you want to continue the utilities, if
You bring it,
if you have to cross the frontage of vacant property to get to your property to take advantage of those utilities, how do you make the person that owns that vacant property pay you the recapture within a certain time period? He may not develop that property, or he may sell that property to somebody else. I mean, if you're running a line across properties
and
that
that-
are
and-
already improved with
and-
homes on
and
them, I
that,
can see how that might work.
in that case, the city ought to pay for these improvements. Why should it be a developer? Why should he be called a developer when he doesn't need to develop the person's property next door to him? If it's a vacant piece of property, why should he improve somebody's vacant piece of property? That should be the city's responsibility.
Now we're
Okay.
talking philosophies here now, so.
Well, okay, maybe Mr. Peterson wants to make a specific motion as to amend Dr. Madonna's motion to add this additional requirement to it.
Well, I don't know exactly how I do that, but,
No,
I would like to have a, time limit put in there that these, recapture agreements be sunsetted, they'd be over with in a reasonable amount of time, according to city lawyer, reasonable amount of time, it has no description.
Well, my opinion is back that
If we set a year,
Are you,
year,
are you proposing a specific year then, or?
well,
or
I'd
specific
leave that
time?
up to the city council, from 1 to 5 years, maybe.
Okay, so-
That would be my suggestion,
okay, would that be your motion then?
yes.
Okay, all right, so that, we have an amendment made that it also include a, a sunset or a limit on the duration of the agreement from 1 to 5 years is set by the city council.
Well, can we do this in 2 votes?
Well,
Vote Mr.
No,
Dr. Madonna's,
you have to vote, what
If
you have to
you
do
just
then is, there's,
Dr. Madonna's.
Mr. Peterson's amendment is on the floor to amend Dr. Madonna's motion. So you have to vote on Mr. Peterson's motion, and first of all, there has to be a second on Mr. Peterson's
Okay.
motion.
We didn't take a roll call on Dr. Madonna's.
No, because we haven't yet.
No, we
All right,
haven't,
So
because
we're
Mr.
now going to
Wait a minute.
amend it.
Well, that's what I'm trying to clarify with the
Yeah.
attorney.
You're going to, Mr. Peterson has made an amendment to Dr. Madonna's motion
Okay.
to also then add this limit on duration. So that is, so he's made that motion. Then there would be, it would be necessary to have a second from the
From the commission,
Mhm. So it was
to add his amendment on there.
to add his amendment, and then you vote on Dr. Madonna's motion as amended, okay?
As amended, right.
So if there is, so,
Okay, is there a second to Mr. Peterson's amendment?
I will second it in principle, but I cannot approve of the term 1 to 5 years. It may have to be longer for some situations. So, Rich, would you agree to, and I'll agree to amend it if we can change the wording to say that, recommend to the city council that a time period be put into any recapture and let that recapture depend upon the area of the city. And let the city work out the recapture as the time frame. What I'm saying is that in your case, it's been a long period of time, but in some cases, and obviously, the way it's structured right now, it's beneficial to start for the person to hook up within the first year, pay 6%. Beyond that, it gets higher and higher. So what I'm saying is that every piece of property in Wooddale may not be as significantly impacted as yours was. So would you agree, and then I would be glad to second it and amend my motion to, that we leave it up to the city council, and only on that basis would it be a case-to-case basis to determine what the length of time of that recapture should be.
I agree to that,
You do?
absolutely.
Then I will second that amendment, so
Okay.
we have the amendment.
Okay, now you,
Go ahead,
yes,
sorry.
would you spell out your amendment to, as you have now restated?
Okay, the amendment is going to be, we're going to continue to recommend to the city council that every recapture agreement have a exit date to be determined by the city council
On top of yours.
on top of the
Yeah,
original.
of course, the amendment.
okay. So now you would have to then, because it's been seconded by Dr. Madonna, you would have to then vote on the amendment,
First, the amendment.
okay?
Okay,
So
separately.
separately, you vote on the amendment,
Okay, this is the vote on the amendment.
amendment.
Okay, we'll call Marilyn.
Okay. Mr. Sy,
Yes.
Dr. Madonna.
Yes.
Mr. Milano,
Yes.
Mr. Peterson,
Yes,
and Mr. Petrella.
Yes.
Okay, now we-
Okay, so then,
Okay.
The
now you
original
have
motion.
the amended motion on the floor. So I don't know whether there's any further discussion on this amended motion. Probably not. Then you, if not, then you would call the question to vote on the amended motion.
okay. Do we have to have a second then?
Well, the motion has been amended. Motion was seconded,
Okay.
and, no, you don't have to have a second. So the
Okay.
motion is right, the posture of the motion right now is that you can vote on it,
Okay.
because the original motion was moved and seconded, and then the amendment was moved and seconded, and it's been
Okay, well,
approved.
Marilyn, we'll have a roll call on,
On this amendment as just stated, that
On the-
there be a
Right.
time limit.
right,
No, on the amended
Uh,
motion,
on the amended motion.
on the amended motion.
motion.
Okay.
Okay. Mr. Sy,
Yes.
Dr. Madonna.
Yes.
Mr. Milano,
Yes.
Mr. Peterson,
yes,
and Mr. Petrella.
Yes.
Motion carried.
Okay. You're welcome.
Okay, the next item is case number 14TA2, medical marijuana land use regulations. The city of Wooddale is requesting a text amendment to Chapter 17 of the Municipal Code of the city of Wooddale. The purpose of this proposed text amendment is to create land use and zoning regulations for medical marijuana dispensaries and cultivation centers as defined by the compassionate use of Medical Cannabis Pilot Program Act, Public Act Number 98-0122. I would like to make a motion to agree with staff's recommendation for the location of the proposed locations of land use for the medical marijuana.
Just to add to it, would you make sure that it says the medical marijuana dispensaries and
Yes.
cultivation centers be in an R2 zoning with special use required?
I too.
I too,
I too, special use.
yeah, I too. I too agree with you.
Otherwise, you'll have them both next door to you, Dr. Madonna.
I got a big lot that I wanted to get in there.
And this operation will be covered under a special use.
The only problem with Dr. Madonna is that dentists can't be licensed to prescribe. May I just make one
Sure.
comment? And this goes to the recommendation as to the location, the providing for a location of the medical marijuana cultivation. Right now, the statute only allows one cultivation farm within a Illinois State Police
District.
Department
Yeah.
district. And we are in District 2, and District 2 embraces, if I can get my notes here. District 2 embraces all of DuPage County, all of Kane, all of McHenry, and all of Lake, and all of DeKalb. So the likelihood of locating a medical marijuana cultivation farm in DuPage County, let alone Wooddale, in this very populous area where you're probably not going to get the, you're not going to be able to satisfy the distance parameters that the statute said, is virtually nil. One concern I have about making provisions for medical marijuana cultivation in an I-2 district is that right now, the facts are that there are no area within an I-2 district that can accommodate, as I understand this, right, John? There's no area within an I-2 district in the city that can accommodate a medical marijuana cultivation farm. So what you are doing on the face of the statute, I think, or on the face of the ordinance, is imposing a restriction which anybody theoretically who wanted to come in and establish a medical marijuana cultivation farm, they can't meet it. So that's going to give them then an excuse to say that, to challenge the classification on the basis that it's not available. Because you're saying with one hand, yeah, you can locate it in an I-2 zone, but from the own evidence that was offered here tonight, there's no place in an I-2 zone that can meet the parameters. My recommendation as an attorney on this would be, is that there be no provision made for a medical marijuana cultivation, simply because it's not going to really happen here. And I know that John made the recommendation on the fact that, on the basis that the statute might be changed.
Right.
I think that there would be, if the statute were changed, there would be ample opportunity for the city to then make a recommendation to amend the ordinance so as to meet that change. So that would be my recommendation. Of course, it's up to the board.
In other words, you just want to go with the,
That would be my recommendation, yes.
do the dispensaries.
Just with the dispensaries.
Okay.
because I had the same problem I faced when I worked for the state's attorney's office, and we were trying to, when the issue du jour in the 1980s was the location of adult uses.
So, well, yeah.
What a lot of them, municipality and county are trying to do is to zone them in areas where you couldn't do that. And then that just offered a basis for their lawyers to challenge the ordinance.
Well, then I'll go right back to my original motion to, just to provide the land use for just the marijuana dispensing operation.
And that's correct. I think, Jennifer, you also wanted that other language, that definition
Yeah, and then,
of a dispensary added, and you could also add the definition of a cultivation center, even though we're not going to provide for it in a district.
That could be done. Wouldn't it be necessary to have a definition for a cultivation center if it's prohibited?
Well, it's not, it's not being prohibited, so to speak. I guess it would not be then to, if you don't want to do it at this time, again, you can defer it to the time when it is necessary to amend the statute.
Just from an enforcement perspective, I think it would be cleaner if we would not add a definition for something that's not being regulated
Okay,
by the
all right,
ordinance at this
all right,
time.
that's fine. Okay.
and then where this is located, this medical marijuana will be a special use in this area.
And then we would just add the definition of the dispensary.
And,
Yeah,
and,
add that to it, because
and
it's
add, yeah, and then add the definition
definitions.
of a dispensary into this.
I'll second the motion.
Any question? Roll call?
Mr. Sy,
Yes.
Dr. Madonna,
Yes,
Mr. Milano,
Yes.
Mr. Peterson,
Yes,
and Mr. Petrella.
Yes.
Motion carried. There's no other business. Motion to adjourn.
but before that, just one small business. I want to just thank Jennifer for the way she presented both of the cases this evening. Even though I didn't agree with one of them, I think as much information as humanly possible for her to get to us was given to us. I wanted to thank her for that, let her know we are reading it.
And-
Thank you.
And the other thing I'd like to add is, Mrs. Schroeder is no longer a member of the board.
Yeah,
She
you said.
had to resign because of conflict of interest.
Oh,
And I want to personally thank her. Between this committee and the stormwater management, she's probably put in 10 years to the city, and I hope the city will at least send a letter of appreciation. You know, 'cause she devoted a lot of time here and a lot of effort, so. Okay, motion to adjourn? Second. All in favor? Aye.
all in favor, okay.
I did want to let you know that the February meeting will be canceled. We didn't receive any petitions. So we'll meet next month.
And let you know, I probably won't be here for the April meeting. I'll be in Arizona.
We're in Arizona.